Negotiating agreements is a key milestone in the FPIC process, as it makes sure that both sides are happy before the project goes any further. There are a couple of steps the community and company will take during these negotiations. But before we go into that, let's look at what has been achieved so far. Once the company and community have agreed to the main points of consent, the following would have been achieved. Communities will have chosen how they wish to be represented. This includes any wishes to involve third parties. Communities will have been involved in assessing and informed of the potential positive and negative impacts of the project. It will have been clarified who has rights to the land, and also how the decision process will move forward. After weighing up the pros and cons, both the company and the community will decide whether or not to move on to the negotiation phase. After all, the company may decide the area is not favourable or feasible. For example, the land tenure assessments may reveal there are both collective and individual rights to the land. Often, land will be held communally, and family or individual rights will be nested within the collective. If so, this may mean that multiple negotiations will be needed first to secure agreement from the collective authorities and then to negotiate with each family or individual about their particular area. There's a lot to cover in the negotiations, but it is critical to be clear it is a negotiation and not a take-it-or-leave-it situation. Communities can then take time to discuss the offer, get advice, and consider what they would like to accept and/or negotiate. In any negotiation, there are parts that are accepted, amended, and countered until an agreement is reached. Neither party is obliged to agree to anything they don't want to, and they have the right to say no at any time. The terms of the proposed agreement that would be formally put forward to the local community include the extent and location of planned plantations, areas allocated to the company, smallholders, or set aside for assessments and other purposes, the legal implications of the agreement and how the agreement will be made legally binding, who will own and manage areas, who will be asked to exchange their rights for compensation, the benefits provided and the process for compensation, how negative social and environmental impacts will be avoided, mitigated, or compensated, what happens in the case of a change of ownership or a change in funding, how disputes will be resolved, and how communities will be involved in implementing and monitoring the agreement. Once an agreement is reached, both parties will carefully go over each point to make sure they have fully understood what they are signing. Once they do, and as long as they still agree, the agreement should be signed by the representatives of both parties. Such an agreement is meant to be binding on both parties. How that is achieved will vary from place to place. It may mean getting the agreement ratified by the local government, legalised, or notarized. Communities are also likely to have their own traditions for making agreements binding on all their members and other parties. Typically, this will be in a public ceremony or even ritual. It is important to respect such events, and the senior parties should be present. Copies of the agreement and all its annexes should then be provided to all parties. This negotiation process sure looks like a lot of steps, but it is crucial in making sure both the company and community are in agreement with what will happen once the project is underway. Both sides need to feel like they have a say and that they are happy with everything they are agreeing to. FPIC does not end here though. Participatory implementation and monitoring will come next.